Our first speaker needs no introduction to this audience, but I will introduce him for our audience at home. Professor Edgar Cahn got his BA at Swarthmore College, his master's and PhD at Yale, and his JD at Yale. With his late wife, Jean Camper Cahn, they co-founded the Antioch School of Law. And they are also acknowledged godparents, shall we say, of the Federal Legal Services Program. The two together founded the concept of time dollars, which has since become time banking as it's gone international. Professor Cahn teaches law and justice and is a driving force behind our LLM program in systems change and clinical legal education. He also directs our community service program. Professor Cahn will speak today on his racial justice initiative, legal theory and strategy to address racial disparity in juvenile justice in education across America. Dr. Cahn.
By now you know for me this is home and you are family, voluntarily or involuntarily, doesn't really matter. I'm just really proud to be at a law school that hasn't lost a sense of mission and a sense that to come into the law is to come into a calling. It's not merely a bunch of techniques and knowledge. It is in fact a calling. I'm going to make a presentation on really one initiative or 1.5 initiatives that I'm involved in right now. About 2 years ago, I was asked by the Vice President of Kellogg Foundation, what could we do in the law about the racial disparity that we see in virtually every public system, in juvenile justice, in child welfare, in terms of kids who get put into foster care, in terms of who gets pushed out of schools. I went back and read the case law and came back with this observation, that the mere fact that a system produces disparity in results in terms of who goes into prison, who goes into juvenile detention centers, who gets taken away from families and put in foster care, who gets frankly put out of school or gets suspended, that we know that there is gross racial disparity. But the law is very clear that unless you can prove that that disparity is the product of intentional behavior designed to effectuate that disparity, that the courts will not touch it. I looked at those cases and looked at another case called that was Cahn, and I came back with both a new legal theory, but unfortunately new legal theories don't necessarily implement themselves unless you go to work on them. And the new legal theory was this. All of the 40 years of cases that I read where attempts to prove intention by statistical disparity or showings of motive, with the sole exception of jury duty assignments, had failed because intent had not been shown, is what the courts found. But so that, and I said to myself, they're looking at the wrong thing. They're looking backwards at behavior and patterns and intent. We need, if we're going to prove intent, to shift the lens forward to another test. Because the Canton case said that if officials choose between alternatives and reject the ones and are on notice of alternatives that will produce harm, and have a choice between alternatives that will not produce that harm and alternatives that do, if then they go back and choose the ones that produce harm and reject the ones that would avoid that harm, then intent can be inferred. The question was how to put officials on notice then in a way that would give them that would make them liable for going back to business as usual. And so what we designed was something called a public, and well, first, when you do something like that, you write a law review article, and then you write a second law review article, and then you footnote the law review article, and then you get real, and then you say, how do I really do this? And what we decided to do was to call for and conduct what we called a public notice forum that was sponsored, in this case, in the first case, by legislators who happened to oversee the funding for the juvenile justice system in Pennsylvania. We had, on the Democrat side, on the House side, we had the Democrat-controlled House and the committee that dealt with families held the hearing. And on the Senate side, we had a Republican who would let the zero tolerance get tough on juveniles, but who was beginning to rethink that maybe that was not doing what he thought it would do. And he held the hearing on the Senate side. We brought forth witnesses because what we had to do was not only show what the present practice was producing and how it was failing, because you send a kid away to detention and you get about a 70% recidivism rate. You keep that kid in community with wraparound services and you get maybe a 20% rate. If you send them to youth court or to another diversion program in Washington, D.C., you get an 11% recidivism rate, 6% for the first 6 months, but it never goes, in subsequent years, it doesn't go past 11%. So we had to stage, literally, alternatives, and we had to put the system on notice. And we brought in the judges. The most powerful group of change agents turned out to be the judges, who said, we're going to stop sending kids to detention now that we've heard this, and we're going to change the rules so that anybody who chooses a more restrictive way of dealing with juveniles than the less restrictive invasion of liberty has to write an immediate written opinion that explains why they rejected the less restrictive alternatives, and that has to be immediately appealable. So they changed those rules, and the governor, who came in, who was not liberal, all of a sudden had a whole block of money available to begin to enable Pennsylvania to stop sending kids away from detention. Our next effort was in Washington, D.C., and what we found in Washington, D.C., we started looking at school suspensions because we wanted to stop the school-to-prison pipeline. And what we found last year was there were 18,896 suspensions in Washington, D.C. 17,000 were from 1 to 10 days, and 716 were for 10 days or more. What we also found was that they had changed the rules so that if it was 10 days or more, it went to an administrative law judge to oversee it, and the administrative law judges found that 66% of those longer detentions were excessive and had no justification whatsoever. We were looking at kids in 4th grade who had dared, you see this, to do things, really dangerous things like kick off their sneakers. Or somebody had actually used a cell phone in the hallway, and that justified 90 days. Well, the truth of the matter, I have 1 minute left. I'll simply say we are now going for a moratorium on suspensions, and we will want as much support as we can get because we think we do not think kids go home and read the Encyclopedia Britannica when they are suspended. Last thing I want to say, and my newest cause is that we need to start asking the clients whom we serve to pay it forward to help others. And I'm going to legal service programs, and I'm going to, and now the clinic in the University of Miami is working with the Veterans Administration, and it's asking them to sign a retainer that they will give help to somebody else, and they're forming ways in which that pay it forward retainer can be honored by setting up something called a time bank. But I'm at the end of my time. Thanks.
Thank you.